I know you've probably only had a matter of minutes to read this opinion, but your initial reaction, please, to the court granting Donald Trump at least partial immunity for his official acts.
I think the bottom line is this decision is really meaningless in a lot of ways. None of the acts that are alleged in that indictment are official acts of the President of the United States. He's alleged essentially to get involved in the presidential election, to try and overturn it, trying to do things that have nothing to do with his powers under the U.S. Constitution. Coming up with fake electors to put before Congress, trying to get his vice president to throw the election to him by using phony electors, trying to put the attorney general in a position to send out a fraudulent letter to battleground states, telling them that there was fraud in the election when there wasn't, that he was spreading the big lie that there was a fraud in the election. None of this is an official act of the President of the United States. Filing false statements with a federal court about there being election fraud is not an official act of the President of the United States. What really irks me about this opinion is that you could just look at the indictment and understand that everything that alleged here has nothing to do with his official acts. This is no different than what President Nixon did in Watergate when he directed his aides to call the FBI, to call the CIA, to call the FBI to tell them to stop the Watergate investigation. Sure, that was official that he was having his aides do this, but this was not something that is under his authority as president to undermine the justice system. It's not Donald Trump's authority as president to try and undermine a presidential election and the peaceful transfer of power.
Well, Nick, as we consider the peaceful transfer of power question, of course, keeping in mind that all of this goes back to actions taken around efforts to overturn the 2020 election and the events of January 6, 2021. It's also worth keeping in mind that while we got this opinion from the court today, we got another consequential opinion from the court last week on January 6 defendants, at least limiting the use of the Enron doctrine, what could eventually be obstruction of an official proceeding. They've sided with that defendant, which has potential consequence not just for him, but for Donald Trump himself in this case. How should we consider that opinion together with the opinion we have got today and what it will mean for this case moving forward?
Well, a couple of things. First of all, the obstruction count that the Supreme Court dealt with last week would not in any way undermine the allegations against Donald Trump. What the court found was, and I totally think this was off base, was that because it was passed after the Enron scandal and in response to the Enron scandal, it has to do with falsifying evidence. Well, in this particular indictment against Donald Trump with respect to the January 6 matter, it does allege that he came up with phony documents, namely the documentation underpinning the phony electors. So in a sense, the decision last week really is not going to have any impact on this case against Donald Trump. Secondly, it just seems to me that what the court did for a Supreme Court that has been so emphasizing history and what has gone on in the past, what they completely overlooked, and which Justice Barrett basically decided in her dissent, was that there was a history here with the initial obstruction statute, Section 1503, that was the only statute that was out there during Watergate. And there were holes in that statute, one of which was an obstruction on Congress. And that was what this statute was intended to cover. So in a way, it was a bad decision, but it's not going to affect the indictment against Donald Trump.
So, Nick, I want to come back to what you said and agree with part of it and also question part of it. On the one hand, you're right that there are certain allegations made in the indictment that even Trump's counsel in the Supreme Court conceded would be, at that point, they were talking about private acts, that is, putting up fake electors, for example, or knowingly certifying improperly the election. At the same time, I've only gotten a chance to read the head notes. As you know, as a lawyer, that's not the way to do this. But I read the head notes. The Supreme Court really specifically went through some that said those things are official official acts that are alleged in the indictments. There are others that I think they said were more troublesome. So in fairness to the Supreme Court, they did go through the indictment and they drew a difference between those two, and they found some things that are official. Do you just think Chief Justice Roberts was wrong?
I don't see how he could possibly be right based on the allegations in that indictment. Everything that Donald Trump did was getting himself involved in trying to undermine the election. He was, for example, in Georgia, he has no constitutional authority to do anything in Georgia with respect to their election in terms of coming up with who their electors will be. That is not the job of the president. Being involved in his own election is a very personal matter. None of this did he have the right to do except to file various court actions, all of which he lost, some 60 some odd court actions that he lost. I don't see how just based on this indictment, somebody can't go through and say each one of these was a personal matter, all intended to benefit Donald Trump, to undermine the election knowingly and willfully, and he knew that what he was saying was all a big lie straight through. I don't see that this is going to be a very difficult matter for Judge Chutkan to look at and decide that all of these matters that are alleged in that indictment are not official acts.
Do you expect, Nick, that Judge Chutkan can do that within the context of a trial already underway? Is this something that can be sorted out within those proceedings, or will everything need to be complete before she can actually set a trial date, keeping in mind she's told the parties they will have 3 months to prepare for trial?
Well, first of all, I haven't read the opinion, so I don't know what the Supreme Court has directed her to do. But certainly the only way to do this is to actually take in the evidence, get proffers on the evidence from the government, and then to make a determination on the actual evidence. An indictment is just allegations. So what you really need here is some kind of indication of what that evidence is, and to have that evidence before the court. So I think you're right. In some ways, you can't really make a decision on this until you put that evidence out there, or at least get a proffer from the government as to what is backing up that evidence. So, yes, I think this gets a little complicated. On the other hand, I have not read that opinion, so I'm not exactly sure what the Supreme Court expects under these circumstances, whereas in any case with an indictment, you only have allegations.
So, Nick, this has been very helpful to me, actually, listening to you about this. But correct me if I'm wrong. I think what you're saying is you don't disagree with what the principles the Supreme Court laid out. That is, to official versus unofficial. You just think it's a really easy case. And when it goes back to the district court, it won't take them very long to resolve it.
Yeah, it's a really easy case. But what really bothers me here is that what they've done is they've played into Donald Trump's ploy of delay, delay, delay. There was no reason for the Supreme Court to have listened and decided this case in the first instance. They could have done this on an actual evidentiary record that would have taken place before Judge Chutkan. Then you would have had real facts to rule on. And here, like I said before, an indictment is not evidence. It's simply a listing of allegations. And so the idea that somehow you have to get that evidence out before you even put it before a jury, or even put it out so that the defense gets a second crack at the evidence when it actually goes to the jury, is contrary to how our system works.
Is there anything in the way of Judge Chutkan getting this resolved pretty quickly?
I don't see it. I mean, I know she said 3 months, but this is a pretty simple case. It's one defendant. I know judges in the Southern District of New York that would have put this to trial in 30 days. So I think it's ready to go to trial. It's a question of how quickly this whole issue about official acts can be decided. To me, it's a no-brainer. Just read the indictment, and certainly the government can back up those allegations with very specific evidence, much of which has already been presented to the public in the January 6th committee hearings.
Well, fair point. And Nick, of course, we're viewing this through the lens of what the implications are for Donald Trump, who has weighed in on this now, posting on Truth Social that this is a, quote, big win for our Constitution and democracy. Proud to be an American. But obviously, Nick, this goes well beyond just Donald Trump. The court is finding here that under the system of separated powers, and I'm reading from the opinion drafted by Chief Justice Roberts, the president may not be prosecuted for exercising his core constitutional powers. What does this mean about how those powers of the president may look different going forward?
I don't think it makes any difference at all. Look, we've only had this problem arise twice in our history. It was with Richard Nixon and now with Donald Trump. I mean, even the other scandals that we had in the past, like the Teapot Dome scandal, the president wasn't involved in that. It was one of his cabinet members. This is such a rare instance for any kind of president to be accused of actually committing a crime. This is extremely rare. Every single president we've had has been above board, has never been involved in criminal activity like these two presidents. There was no reason to have this opinion and delay this case till after the election. I mean, that is effectively what may have happened here. Again, I haven't read the opinion, and it may be that Judge Chutkan can cut through this pretty quickly. But it's outrageous that so much time has gone by simply to state a principle that a president who's exercising his normal constitutional powers cannot be prosecuted for a crime. There is nothing extraordinary about that principle or about that rule.
Nick, I wonder, as somebody with prosecutorial experience, is there anything that the special counsel could have done to bring this case more narrowly to avoid this problem?
I don't see it. I mean, everything they had in here essentially alleged a overall plan, starting with the big lie that Trump lost the election, that there was fraud in the election, that there were dead people that voted, et cetera, et cetera. All of that surrounded all of the different acts that Donald Trump took. They're all alleged in the indictment. What the special counsel did do was to try and get this to the Supreme Court immediately, bypassing the circuit court, just like we did in the Watergate case with the tapes argument, which the Supreme Court then did accept. I mean, the whole thing just to me feels a lot more political than it did back in 1974, when you had members of the Supreme Court who were appointed by Richard Nixon, who basically came down on the side of the special counsel and against Richard Nixon, whereas here the feel is that these Supreme Court justices that were appointed by Donald Trump did everything they could to buy into his delay strategy.
Well, and of course, it was the 6 conservative justices that ruled this way. It was the 3 liberal justices who dissented. I read earlier, Nick, from the dissent drafted by Sotomayor, who reads in part at the very end, "Never in the history of our republic has a president had reason to believe he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law." She ends her words with fear for our democracy, I dissent. In our final minute here, Nick, how does this make you feel about the state of American democracy in these 3 branches of government?
Not great. I'm not feeling good about the Supreme Court. Between what we know about 2 of those members who should have recused themselves on this decision, and how this came out and how this was dragged out, I'm really not feeling good about the state of our democracy compared to what happened back in 1974 with a Supreme Court that was appointed mainly by Republican presidents.